To have a decision by the National Executive Council to disband his Provincial Executive Committee overturned. You saw him speak to our reporter Griselda Lewis outside the court earlier, but now let's go live to the court proceedings.
To disallow this affidavit by Mr. Mahumapelo and to disallow submissions which are to be made by counsel on his behalf when there's not been any compliance with the time frame. There is an authority of the Western Cape division, which I'll ask my junior to find, which says that in an urgent application, the applicant is entitled to nominate the time frames upon which compliance by the respondent with filing of documentation must take place. And the respondent ignores those time frames at his or her own peril. So we know that Mr. Mahumapelo has ignored those, and his mere say-so that he supports the relief sought by the applicant, then it's fine, he can support that relief, but he can't then come and argue from the bar through counsel. He can do whatever to provide assistance to the applicants, but he should not be allowed then to make submissions from the bar when he has completely disregarded the rules of court and the timeframes that have been prescribed in this application. So we submit, my Lord, that the submissions to be made on behalf of Mr. Mahumapelo should not be received, and the matter should proceed as it stands with the parties that are engaging one another as applicants and respondents clearly defined by way of the affidavits. In paragraph 3 says that he has considered that his interests are sufficiently covered and advanced by the applicants, but he has provided no application to this court as to which of the aspects of the applicant's case are no longer sufficiently covered, which necessitate him making separate submissions. He has not given us any affidavit whatsoever. So he was obliged, my Lord, to provide an affidavit to court, ask for condonation, and also stipulate which of the aspects in the applicant's affidavit have not been sufficiently covered. That was not done, as the court pleases.
Well, I know from the citations and parties that there is already a fourth applicant.
Yes.
So if he's joined or to party, he will become the fifth applicant.
Yes, if there's an application to that effect, he was going to become the fifth. So no application has been made whatsoever.
Yes.
So all what he says is that I associate myself with the submissions of the applicant, and there is nothing unusual, my Lord, with the respondent coming to court and say that I associate myself with what the applicant is saying. Then does it? It ends there. But what he can't do, then he can't then say that I am now going to argue as the applicant, because he must make an application and the court must consider that application, grant or refuse it. There is no such application, my Lord. As the court pleases.
Thank you, Mr. Mpho.
As it pleases the court, my Lord, I will try to be brief because I would like the court to really get on with the actual case and not with technicalities. The issue is this, my Lord. Firstly, we are in an urgent court. A learned friend has considered that the affidavit, the explanatory affidavit of Mr. Mahumapelo was handed up in court last Tuesday. And also the heads were also handed up last Tuesday or Monday. we heard that he quoted from. Now, my learned friend then goes on to say that for the first time, Mr. Ngaitobi has said he represents the 3 applicants. That's not true. I know that my learned friend was not here on Tuesday, but his junior was here, so he is assumed to have been here, because I'm sure his junior would have told him that that's exactly what Mr. Ngaitobi said to the court, and it's on record last week, Tuesday, that he represents the 3 applicants, and I also said to the court, I represent the 4th applicant, and I explained, as I did earlier this morning, that the 5th applicant, or rather, the 2nd respondent has practically become a 5th applicant. As he says in his affidavit very clearly, the 3 important paragraphs are 3, 4, and 5, where he says, at an earlier stage, he considered his interest to be sufficiently covered by the applicants. And then he says, after proper consideration or reconsideration, he has now decided to be represented separately. And then he says, I associate myself fully with what is said by the applicants. So it's also not true that he hasn't said to what extent he associates himself. But be that as it may, my learned friend quite correctly concedes that this is not something unusual. Your Lordship is very experienced. He will know that it so happens that sometimes, for example, if it's members of the board or something like that, you cite the rest of the members as respondents. Then some of them might agree with the applicant, others might not agree, and those who agree will then be viewed by the court as applicants. All of us have been in many cases that where that has happened. I wouldn't even cite examples. So the question really then is not about whether Mr. Mahumapelo is a party to this proceeding. That is common cause. The issue seemingly from the side of the ANC is simply to deny Mr. Mahumapelo his right to legal representation. Now, unfortunately, that is not something that the other side can do. If Mr. Mahumapelo has correctly chosen to associate himself with the applicants and he has elected his legal representation, then there is nothing, quite frankly, that the other side can do. I don't know what they are scared of, or why it is that Mr. Mahumapelo must not be represented by a legal practitioner of his choice. In this country, at least, I didn't think I was going to meet up with that kind of thing. One met with it in one of the neighboring countries, but the right to legal representation, your Lordship knows, is something that is sacrosanct, that is fully guaranteed in our Constitution, and a person should preferably be represented by a representative of their choice, unless if there were some compelling reasons why that should not be so. Happens every day in our courts, lower courts, higher courts, everywhere. Now, my learned friend says that the fifth respondent did not file a notice of intention to oppose. That's true, he didn't. That's simply because he's not opposing anything. And that's why he didn't file a notice of intention to oppose. And what he did file is an explanatory affidavit in this court, which does two things with respect, my Lord, which explains how the sequence of how he made the decision, and also explains that he associates himself fully with what is stated in the founding affidavit. In other words, everything that is there, he agrees with. So the purpose of then filing another affidavit regurgitating the very same thing would have just been superfluous and just create paper, unnecessary paper. My little friend is quite correct. If there was an aspect, for example, that you are saying, no, but I disagree with the applicants in this and that area, then he would have been obliged to expand on this affidavit. But once he uses the word fully means fully. That means he associates himself with the founding affidavit. So, my Lord, with the greatest respect, let us get on with the matter. Let us accept that for practical purposes, as it is usually done, the second respondent has become the fifth applicant, and simply just proceed with the matter on that basis. And my Lord, if I don't want to get into the issues of this case, but simply to say that your Lordship knows that this is a very serious matter that deals with weighty issues of constitutional importance, which might end up in the Constitutional Court or even in other courts. And what was said in a similar case, my Lord, if I may hand up. A very short reference. The Lordship might as well hold on to that case because that's going to be cited many times. It's the leading authority in matters of this kind. It's the Ramakatha matter of the Constitutional Court. What happened, my Lord, is history is repeating itself, because when we argued that matter in the lower court, all sorts of technical points like this one, some of them, but I think they were better than this one, were raised there. Many of them, which are listed in if your Lordship goes to page 10 of that judgment, you will see, I'll just read the heading. There was something called service grounds. It was all about you didn't serve all the branches and so on and so on. Then at page 13 you see it says the failure to cite branch executive committees and elected provincial conference. Then at same page the application is premature. The next page, failure to exhaust internal remedies, and so on and so on. And this is what Yakub said at page 10, paragraph 18, my Lord. The appellants were denied the opportunity to have the merits of their application heard on the basis of technical procedural grounds. We have come to the conclusion that these grounds were incorrectly relied upon by the High Court. I now proceed to evaluate each of these grounds. And they were duly kicked out, and the Constitutional Court duly went on to deal with this matter. And the basis, one of the bases of that was that this is a matter that concerns, quite frankly, not just members, hundreds and thousands of members of the ANC, but seeing that the ANC was the ruling party in that province, which was to state as it is here, it actually affects the entire population. And so the court was not going to be waylaid into deciding the matter on technical grounds. But here, this is not even a technical ground, my Lord. I don't even know how to categorize it. It is a simple complaint of trying to muzzle the legal representation of Mr. Mahumapelo unfairly and without any reason. It should be rejected, my Lord, and as I said, we should just go on, get on with the matter. Let's go.
Could I just find out the matter was on the roll last week, Tuesday.
That's correct, man.
There is a script down until Friday. Between that time and now, there surely must have been enough time for Mr. Mahumapelo to indicate by way of application to intervene or to become a party of this proceedings by now.
Yeah.
Filing whatever.
Yes, my Lord.
Answering papers with condonation and things like that.
Yes.
That would have been a different route.
That's
the ideal route, in fact.
No, that's correct, my Lord. That's why my very first words that came from my mouth, my Lord, was that we are in urgent court. The Lordship must remember that the situation, the Lordship is quite correct, by the way, but I'm simply explaining why that did not happen. The Lordship must take into account that when this affidavit was filed, it was literally on the day. Theoretically, the case could have been heard on that day, which was the Tuesday. The view that we have taken, my Lord, was that the affidavit that has been filed sufficiently explains why he has taken this step. And as to the question of your Lordship of saying, applying to intervene as a party, that would of course not be necessary, my Lord, because he's already a party. But the condonation point is a good point. The first point about intervening, he could hardly apply to intervene as a party, as he already is a party, and he has said that he associates himself with the applicants, and he has explained why. He says that it was after what he calls proper consideration. So, although there's no heading that says condonation, my Lord, with respect, that affidavit would be sufficient in urgent court for this court to condone the explanation, so to speak, because that's the explanation that's before the court. But that knife, my Lord, with the greatest respect, cuts both ways. Just as we, last Tuesday, this affidavit was filed, the other side could have filed an affidavit opposing this affidavit and explaining the grounds of their opposition, and they failed to do so in the past 10 days or so. And so the same question could be asked from them as to if they perceived any prejudice, and really that's what it's all about, my Lord. Is there any prejudice to the respondents simply because Mr. Mahumapelo is now represented, which he indicated last week, and there has been no affidavit filed by the other side that says we oppose this affidavit, we don't agree with paragraphs 3, 4, and 5. We think that it's not true. So the court must accept as true those amendments made at paragraphs 3, 4, and 5, because nobody has opposed them. And the court must simply evaluate those amendments and put itself in the position of someone who's a respondent, who's simply saying, I am associating myself with the applicant, so I don't need to make any new submissions, and who in any event is already a party to the proceedings. And that's those two crucial elements, my Lord, is what I would implore the court to take into account. A, is already a party. B, there's no prejudice. And if there was prejudice, we would have been told about it on affidavit. And so what really we are imploring the court to do, my Lord, is just to take a robust approach and simply let us get on with the matter and not be bogged down by procedural technicalities.
Thank you.
Yes, please.
Are you going to make my job easier? No, my Lord, my position is clear. I'm for the first to the third applicant. It's true that on the last occasion I informed the presiding judge that I'm acting for the first to the third applicant. So that remains the position.
To the third?
Yes, 1 to the 3rd. Until the affidavit of Mr. Mahumapelo was filed, which explained that the 4th and the 4th applicant and the 5th respondents were represented by Mr. Bofu. So my position is uncontentious.
Briefly, my Lord. My Lord, the important caveat which both my learned friends do not mention to your Lordship about Mr. Mpofu indicating to the court last week Tuesday that he's representing Mahumapelo and giving an affidavit and Mr. Ngogaitobi informing the court that is appearing for the first to the third applicants, is that it was placed on record by the junior that Mr. Mpofu says he was accordingly representing me in my absence, that an objection is going to be made to that. So that is what they omitted to mention. So it was mentioned at that stage, given the fact that the matter was not argued on Tuesday at all. So then that objection still remained, and then that is why then the objection is being put forward as a first opportunity now. But secondly, then we are told that there is no prejudice to the first respondent. That cannot be correct, my lord, because we are told from the bar that there's no prejudice. There is no affidavit which says that there is no prejudice. So the prejudice is clearly manifest, because if your lordship will have also seen the heads of arguments of Mr. Mpofu, where then he goes to attack the answering affidavit and the footnotes in the answering affidavit, and yet there is no affidavit to that effect. So the prejudice is clearly manifest. But thirdly, my lord, Mr. Mpofu has correctly conceded that he has not made an application for Mr. Mahumapelo to be joined as the fifth applicant. Mr. Mpofu fails to make a distinction between a party who is already cited as a respondent and the joinder of that party as the applicant. So there is no application for Mr. Mahumapelo to join as the fifth applicant. Secondly, Mr. Mpofu correctly considered that there is no application for condonation. What we are now told is that the court must read this affidavit, this one-pager, as a condonation application. That is clearly absurd. So, just on those two, my lord, then he fails. He fails to make out a case to be joined as a fifth applicant. First, there is no application for him to become the fifth applicant. Secondly, there is no condonation. Why? Then he only entered the fray now. So just on those two, my lord, the application then can be granted for him to stand as a fifth applicant. We are now told that we are trying to stop Mr. Mahumapelo from exercising his constitutional right to legal representation. That is entirely not correct. The right to legal representation rests with everyone, but the rules of the court have to be observed. And when they are not observed, you ask the indulgence of the court. And that is what Mr. Mahumapelo did not do. And for that, he fails. So, we are told lastly that Mr. Mahumapelo says in his one-pager, I don't have any new submissions to make. And that actually demonstrates the prejudice that the first respondent will suffer, that it will be saddled with same submissions which are no different from the submissions which will be made by the applicants. The same applicants that Mr. Ngogaitobi says he's appearing for. So the same test, insofar as Mr. Mpofu said that there are no new submissions that he wishes to make and no new allegations which he wishes to make, apply when an application for admission as a friend of the court then happens. Because in order for the court to allow you, you've got to demonstrate that I will be making submissions which are not already covered by any of the parties. So he's saying that it's just coming to regurgitate the submissions that will be made by Mr. Ngogaitobi, and that's really the absurd. As a court, please.
I don't want to belabor this point. Just to correct my learned friend, I know he wasn't here, so I'm not impugning anything on his part. But the issue of it being placed on record that there was going to be an objection simply did not happen. His junior did indicate to us when we went to see the judge as we were walking that he had an issue. In other words, if the matter was heard, he probably would have raised it. but it certainly was not raised in court. I just wanted to correct that. And I know my learned friend was not here, so as I say, I'm not suggesting that he's misleading the court, but it's just important that the court has the correct facts. And as far as the last point is concerned, Rule 612, my Lord, is exactly for condoning non-compliance with the rules. That's correct.
My Lord, I'm not responding, but my learned junior, of course, he wants to make sure that his reputation is not impugned.
Sorry.
I'm not.
I mean that my junior would like to make sure that his reputation is not impugned, because he says he has raised this issue and he raised it in chambers,
Yes.
and the respondents know that.
That confirms what I've just said. Thank you.
Well, you didn't put one of the council in the box on the other. Tell me exactly what happened. But I am inclined to adjourn briefly to consider the national before we come there. But I would have hoped to deal with the merits of it being a special allocation.
My Lord,
It was an ideal situation, but now I have to overcome preliminary skirmishes before I get to the meat of the matter. I would have thought that the parties would come to some agreement. But before I go, I just want to bounce off. If you may sit down.
that's good.
I just want to bounce off Mr. Nkari. I am in an urgent court here. If I would be inclined to reserve my judgment on this issue until we come to the question of agency, would the ANC be prejudiced? I know you've raised prejudice in regard to the involvement of the fifth applicant, but if I would have to decide this matter that is raised now, together with the question of the agency, would the first respondent have probably given this?
We are happy with that, my Lord. We are happy with that, my Lord.
Yeah.
My Lord, I'm sorry, I know your Lordship is contingent. I simply wanted to bring something to the attention of the court, particularly given that the court has kindly made this practical suggestion, which is simply this, my Lord, that irrespective, your Lordship will probably maybe comment on this in his judgment or at some stage, but your Lordship must please bear in mind that irrespective of the technical point, it's not going to change anything because I represent the fourth applicant anyway. So that's a matter which supports your Lordship's approach that one should go on and your Lordship can then comment on the matter, but it's actually not going to make any difference.
It does not affect you.
Well, my preference is to get going with the case on the basis of your Lordship's suggestion that judgment on the technical point would be reserved, or ruling on the technical point would be reserved.
Yeah.
If your Lordship wishes to take an adjournment now, I can't stand in the way. But if it is at all possible to get started with the argument, we've tried to set aside 4 hours. I'm not sure if 4 hours will be too long or too short, but it would be preferable to us to get started with the meat of the case.
Yeah, I'm not looking forward to that. People are surprising. You're ambushing me.
Well, you know, Mr. Mukari, it's not the first time.
Well, okay, I will not adjourn. I will go straight into the question of the agency of the matter.
Thank you, madam.
Yes, so your Lordship is going to deal with the agency first.
Yeah.
Yes, so then in terms of the sequence, then when it is the agency, then we are starting ourselves.
No, my Lord.
No, but that's the practice. I mean, the party that raises, exactly, I mean, the party that raises an objection is the one that starts. It was only, what was discussed in chambers was that it's only if your lordship was going to deal with everything that it would follow the normal process. That's what was said.
I'm not going to waste time, but the first respondent will start.
Indeed, as a
Tell
copy.
me why the matter is not urgent.
That's right. Thank you, my lord. My lord, we have prepared extensive heads of arguments. And if I may refer your lordship to our heads of arguments which we submitted, your lordship will see that we first deal with the striking of the matter from the roll for violating the agreement between the parties at page 3. That is fallen by the wayside, my lord. We are no longer asking for the striking of the matter from the roll on this. Yes, that's right. So that is fallen by the wayside. No, the matter did not proceed on that week that we wanted it to be struck from the roll. So that's why I'm saying the issue no longer arises.
Yeah.
So what still remains is paragraph 5 of page 3 of our heads of arguments, where we want the matter to be struck from the roll for lack of urgency, and we motivate that in detail, my lord, from page 5. So paragraph 3, we simply flag it and we deal with it in detail from paragraph 10, page 5 of our heads of argument. I would like to deal with urgency in 2 compartments, my lord. Firstly, it is in respect of what steps the applicants took from the date when the decision to dissolve the North West PEC was made on the 30th of August 2018 and communicated on the 31st of August 2018. I say so because it is common cause that the application was only launched on the 26th of September 2018, 24 days later. What the applicant was required to do in the founding affidavit was to deal with the delay between when it became aware of the decision up to when it launched the application. That is not in the founding affidavit. Your Lordship will see that in the founding affidavit, if I take your Lordship quickly to the relevant portion of the founding affidavit, your Lordship will see that the agency is dealt with from page 21 of the founding affidavit from paragraph 26. What is being said by the deponent to the founding affidavit from paragraph 26 all the way up to where the subheading on agency is concluded at page 29, paragraph 49, does not provide any shred, not an iota of explanation as to why there was a delay of 24 days. What we see an attempt being made to do so is in the replying affidavit. The Lordship will find the replying affidavit, which starts at page, It starts at page 389. 389. It should be the last bundle. I don't know how the last bundle has been identified. It should be the very last bundle.
I do have it, thank you.
Thank you, my lord. So this is the replying affidavit. Your lordship will see that from page 391, paragraph 7, there is now a long explanation that is sought to be made in paragraph 7, 8, 9, up to 9.4 as to why the application is urgent, and we are told about the letter which was written by the attorney on the 4th of September, on the 6th of September, and we are not told about what steps did the applicants take when they received no response, and whether it required them to wait for the entire 20 days since that time. But we have stated in our heads of arguments, which is a tried law, that the applicant cannot make out a case in the replying affidavit, new facts which were not canvassed at all in the founding affidavit. So what is clear from the founding affidavit is that the applicants made no attempt whatsoever to appraise the court with steps they took from the time they became aware of the decision, and for the first time were told about this letter from the attorney. In that regard, my lord, if I go back to our heads of arguments, we have cited the authority of this court in page 6 of our heads of arguments, which has been referred to several times by judges of this court. And this is the matter of several matters on the urgent roll, 18 September 2012. It was by Vepena J. He quoted, we quote paragraph 7. But most importantly, in his judgment, he quoted the unreported judgment of Noche, paragraph 6 and 7. And this is quite opposite. It says, the importance of these provisions, and now that's Rule 612B, is that the procedure set out in Rule 612 is not there for the mere taking. Noche AJ said in East Rock Trading 7. And then he quotes paragraph 6 of it. The import thereof is that the procedure set out in Rule 612 is not there for taking. An applicant has to set forth explicitly the circumstances which he others render the matter urgent. More importantly, the applicant must state the reasons why he claims that he cannot be afforded substantial redress at a hearing in due course. The question of whether a matter is sufficiently urgent to be enrolled and heard as an urgent application is underpinned by the issue of absence of substantial redress in an application in due course. The rules allow the court to come to the assistance of a litigant because if the latter were to wait for the normal course laid down by the rules, it will not obtain substantial redress. It is important to note that the rules require absence of substantial redress. This is not equivalent to the irreparable harm that is required before the granting of an interim relief. It is something less. He may still obtain redress in an application in due course, but it may not be substantial. whether an applicant will not be able to obtain substantial redress in an application in due course will be determined by the facts of each case. An applicant must make out his case in that regard. Then, paragraph 9 at the bottom, we quoted paragraph 9 of the judgment by Noche AJ, where he said the following: it means that if there is some delay in instituting the proceedings, an applicant has to explain the reasons for the delay and why, despite the delay, he claims that he cannot be afforded substantial redress at a hearing in due course. I must also mention that the fact that the applicant wants to have the matter resolved urgently does not render the matter urgent. The correct and the crucial test is whether, if the matter were to follow its normal course as laid down by the rules, an applicant will be afforded substantial redress. If he cannot be afforded substantial redress at a hearing in due course, then the matter qualifies to be enrolled and heard as an urgent application. If, however, despite the anxiety of an applicant, he can be afforded substantial redress in an application in due course, the application does not qualify to be enrolled and heard as an urgent application. So Noche AJ says that if there is a delay in the launching of the application, that delay must be explained. And this is what we say, that that delay was not explained in the founding affidavit, and on that basis, it means that the applicant has not satisfied the requirements of Rule 612B. That is the first attack of the agency. The second attack now goes to directly Rule 612B, which requires two mandatory requirements to be met. The first one is substantial redress, and then secondly is that if you are not afforded substantial redress, then irreparable harm, which is less than the irreparable harm which is considered when the matter is to be determined on whether an interdict is to be granted or not. We have mentioned those requirements, my Lord, you'll see at page 10 of our heads of arguments, paragraph 17.1, where we say, explicitly state the circumstances which render the application urgent, and we say that that has not been explained in the paragraph that I've referred to in the founding affidavit. What has been explained, my Lord, in those paragraphs that we have referred to in the founding affidavit is that the decision of the NEC to disband the PEC is unlawful. And because it is unlawful, the provincial conference that is to take place in February 2019 will be convened by an illegal PEC, PTT. My Lord, that cannot be the basis.
That is a task team.
That is the task team. They call it provincial task team, PTT. So that's the basis for agency. But my Lord, in order to find agency on that ground, you've got to prima facie, because at the level where the court considers whether the matter is urgent or not, the test and the threshold is lower. So you've got to demonstrate prima facie that first, the NEC which disbanded the PEC does not have the power to do so. So it has no authority. Then you are able to say that, my Lord, here is a body which purports to exercise the power it does not have, and it has exercised that power, and it has put in place a structure which has no legitimacy because that structure cannot be put in place in the first place. But that is not the case that is advanced by the applicant. The case that is advanced by the applicant is that, one, they concede that the NEC of the ANC has the power in terms of Rule 12.2.4 of the ANC Constitution to disband the PEC. So they admit the power. But secondly, they also admit, my lord, that once the power is exercised, meaning that the PEC is disbanded, in terms of the very same Rule 12.2.4, the NEC is obliged to appoint a PTT. That is admitted by the applicants. But then, when they motivate agency, they say that it is urgent because the structure that is to organize the provincial conference to take place in February is an illegitimate structure. The sole reason they give is because the NEC did not follow procedure, and secondly, it was not necessary for the NEC to disband. So that is the crux of the matter when they motivate why the application is urgent. But that cannot be the basis, because the basis in terms of Rule 6.12b is that you must demonstrate that you will not be afforded appropriate redress in due course. But they will be afforded appropriate redress in due course. Because if it is found that the NEC could not disband the PEC, then the court will set it aside. And the court will be able to deal with, in terms of Section 172, 1B of the Constitution of the Republic of South Africa, to couch an appropriate remedy. An appropriate remedy to be couched by the court cannot be speculated upon purely on the basis that the court may do one or two of the things. But what the court must satisfy itself with in determining whether the matter is urgent is whether the applicants will still be able to set aside the decision of the NEC. And that right remains with the applicants irrespective of whether the conference takes place or not. But we understand the applicants to be saying that what they're going to miss, or the boat that they're going to miss, is the reinstatement of the disbanded PEC back into office for the remaining 2 months before the conference take place, so that the February 2019 conference should be organized by the disbanded PEC. That is what we are told. As to why they believe that the provincial conference should be, as a matter of fact and law, be organized by the disbanded PEC is not clear, particularly in the light of their admission of the power of the NEC to appoint a PTT. So that is really then the crux of their matter, that we want the old PEC to take office so that it must be the one to organize the provincial conference. But there is nowhere in the Constitution where they can point out that once a PEC is appointed, or once the PEC is elected, that PEC must remain in office until its term comes to an end. There is no such provision. Otherwise, there will be no need for Rule 12.2.4. Rule 12.2.4 specifically, my lord, deals with situations where the NEC has a power to disband a properly elected PEC. That's precisely what it does. It does not say that the NEC has the power to disband an improperly elected PEC. It says it has the power to disband a PEC when it is necessary to do so. And necessity, of course, it goes to the merits, because it's a threshold which then the court will determine in the light of the decisions of the court regarding discretionary powers given to the decision maker. But you don't even go there. So what your Lordship has to satisfy yourself with is these applicants, on objective facts, because when you determine agency, you're not determining it on the basis of the say-so of the applicants, but you determine it on objective facts. On objective facts, are the applicants' version to be accepted when they say that the matter will become moot when the conference has taken place in February? We submit not, because the right to challenge the decisions made by the NEC remain a life issue, and that remedy they can get it at any time. As to whether at that time, if the court finds in their favor, the court will simultaneously set aside all decisions, then that is a purview of the court in terms of Section 172(1)(b) of the Constitution, where the court will exercise a discretion as to an appropriate remedy. So we submit, my Lord, that on both grounds, first, explaining why the matter is urgent, no proper explanation has been given, but secondly, that they will not be afforded appropriate redress in due course. That explanation has not been given. If I turn, my Lord, to page 8 of our heads of arguments. Yes, my Lord. As a court, please.
Well,
Okay,
that's developments
yeah.
at the South Gauteng High Court.
That's right, yeah. The application that the South Gauteng High Court to challenge the ANC's NEC decision to disband the North West PEC. And we understand that the ANC lawyers want the court to disallow Supra Mahumapelo's application,
yeah,
saying that it's added at the last minute. So we're going to listen in. As soon as that resumes, we'll take you back there. Let's go for a break.